Hi everyone, welcome to our webinar today on how founders can succeed in the startup ecosystem. My name's Olivia and I'm a Senior Associate in LegalVision's corporate and commercial team. I'm joined today by my colleague Malaikah Khattak, who's a trainee solicitor in our corporate and commercial team. A couple of quick housekeeping items before we get started. So you'll receive the recording and slides of this presentation in your email following our webinar today. During the webinar, you can submit your questions in the Q&A box in the webinar, and we'll aim to answer those at the end. And we'd love it if you could please complete some feedback at the end of today's webinar. That'd be really helpful. Also, all attendees are eligible to receive a free consultation with our team to discuss how we can help you with any of your contracts or legal needs for your business. So to request your free consultation, you can provide us with your contact details in the survey that appears at the end of the webinar, and our team will get in touch. So today we'll be discussing, obviously focusing on startups and discussing these topics. So setting up your business with a sustainable business structure, the key risks to look out for in customer contracts, how to incentivize your business's key contributors, protecting your business's intellectual property, and growing your customer base. So what does that mean for privacy considerations and direct marketing and spam law considerations? We'll then wrap up today's meeting with a Q&A. So as mentioned at the end of the webinar, we'll be answering some of your questions. So yes, there's a chat function in this webinar. You can submit any questions that you have and we'll aim to answer those at the end. So let's get started. So now I'll briefly speak about your business structure and founding documents. So when thinking about starting your new business, you'll need to consider how to structure the business. It's super important to think about that from the outset, because by choosing the right structure now, you can limit your personal risk. You can position the business for investment and growth, and you can also carry out efficient tax planning of the business. Another consideration that's often overlooked is public perception. So often, a company might look more professional, for example, to investors, stakeholders, and customers. And so that public sort of perception is really important to consider as well. There are many ways to structure your business, such as, a sole trader or a partnership, but most businesses will choose a limited company structure from the outset. Some of the reasons for this are that there's limited liability for shareholders. There are potential tax advantages, particularly as you grow and have more revenue. The ability to grow the company flexibly, and it allows you to efficiently raise capital and grow the business through the issuance of new shares. So you might want to consider a group company structure as well if you're thinking of a company. This involves setting up a holding company, which will sit above and hold 100% of the shares in the trading company, or you can have multiple subsidiaries or trading companies underneath that holding company. So it's particularly beneficial in situations where the business has valuable intellectual property or other valuable assets that it owns, as these will generally be held by the holding company, and therefore will be safe from any liability that the operating company incurs. So if the operating company is ever sued, for example. It also allows you to sort of operate different business arms through different operating companies that sit underneath the holding company in that group structure. This will limit liability across, different businesses, and also, can allow you to sort of distribute revenue across the companies, which can be helpful from a tax perspective. So it's a really good idea to speak to a tax and legal specialist to determine the best approach for your circumstances. Now, with a company, it's really important to have the right documents in place to document the agreement between particularly co-founders, but potentially as you grow and bring other shareholders on as well. So the kind of key documents that a company will need to have in place are the Articles of Association and the Shareholders Agreement. So I'll quickly touch on the Articles of Association. Now, these articles cover some really important sort of topics. So for example, the rights that attach to the shares. For example, what income rights, what capital rights, those shareholders have, and voting rights. When I say income rights, often, things like dividends as well, what rights to dividends those shareholders will have. It might be different for different classes of shareholders as well. So for example, if you have a family member investing into a company, they're giving you some money and they want to be a shareholder, but you don't want them to necessarily have influence over company decisions, you might give them sort of a different share class, which might, for example, not include voting rights. In addition to the above, you can protect the company from issues in the future by including, there's other various sort of really important topics that are incorporated into the company's articles of association. So firstly, what happens if a shareholder wants to sell their shares? Do they have to offer those shares to the remaining shareholders first? And then, once, everyone's been offered those shares, if no one wants them, does the remaining shareholders get a say in who the new shareholder is? So who that person that they're selling the shares to is. What happens if a majority shareholder wants to sell the company, but a minority shareholder doesn't, and they're potentially holding up the sale of the business? You can potentially include some things in there, for example, drag along rights that will force the minority shareholder to also sell along with the majority shareholder. And another, important one is, are there circumstances in which the shareholder has to sell their shares back to the company? So for example, if they leave the company, they're no longer working there, and you don't want them to necessarily continue holding shares, you can sort of, for example, force them to sell their shares back to the company or offer those shares back to the company. So board meeting and decision-making by directors are also covered in the Articles of Association. So for example, how often the directors need to meet, and sort of important decision-making clauses in the articles are particularly important, especially where there's an equal number of directors, as the articles can set out various options for if there's a deadlock or equal decision-making between the directors, to set out a process for resolving that deadlock so that the business can still continue to operate. The other document is a shareholders agreement. So that's the contract between the company and each of its shareholders, setting out the personal rights granted to the company or to the shareholders. So importantly, the shareholders agreement will cover provisions such as any vesting rights attached to the shares. For example, if certain people's shares are subject to vesting, that will potentially be contained in the shareholders agreement, among other agreements potentially. What decisions require shareholder consent versus what decisions require board level consent, as well as, if there are founder directors, what decisions need their approval in order to be passed through. Confidentiality protections are included in there, so to protect the confidential information of the business that the shareholder might have access to. And also non-compete provisions. So for example, if you want to prohibit a shareholder from starting or joining a competing business or soliciting the company's clients or employees, that would all be set out in a shareholders agreement. So next, I'm going to pass to Malaikah to talk through customer contracts, and she'll take you through some of the key risks to look out for.
Thank you, Olivia. So customer contracts are extremely important to manage your relationship and set out expectations with clear and defined terms around things like payment, delivery, and so on. And there's a number of key legal risks that you should look out for when considering your customer contracts, which we'll consider. So one of the key terms in your customer contract is the liability clause. It's really important that you're capping your potential damages in case something goes wrong, especially where you're providing the services and goods, because you're taking on more risk here. So your contracts should clearly state the maximum amount that you're liable for and under what circumstances. This can be, for example, 100% of the price that the customer pays to you. And it's also essential that as the service provider or the supplier of goods, as you take on more liability than the customer would in most cases, it's really important that you're including those caps in there. But when deciding what liability cap to put in place, you need to think about what risks you'll be taking on and what's likely to go wrong. Termination clauses are another really important area. Your contract should clearly define the circumstances under which either party can terminate the agreement. So you should include notice periods and any obligations that might survive termination of the contract. So for example, you might specify that 30 days written notice is required for termination, and it's also market standard to state that confidentiality obligations continue after termination. Intellectual property rights can also be a minefield if you're not handling them correctly. So your contract needs to clearly state who owns what IP, especially if your service involves creating something for the customer. Typically, any IP will vest in the service provider and then licensed out to the customer for their enjoyment and use of the services. So if you're licensing out your IP, spell out exactly what the customer can and can't do with it. In today's digital age, data protection and privacy are more important than ever. You need to ensure that your contracts are compliant with the GDPR and you're also complying with other relevant regulations. Make sure that you're outlining how you'll handle customer data, your security measures, and what happens to the data if the contract ends. Payment terms are, of course, crucial. Specify not just the amount that you're getting paid, but when it's due, acceptable payment methods, and consequences for late payment. Don't forget to also address currency and tax implications, especially if you're dealing with international customers. This will mitigate any ambiguities around payment and ensures that you get paid on terms that you're happy with. And you can also avoid costly disputes later on down the line when you have clear payment terms in your contracts. Talking about dispute resolution clauses can also save you time and money if disagreements arise. So you should be specifying the governing law and jurisdiction for any legal proceedings. And this is really important, again, when you're dealing with international counterparties. Most businesses don't want to settle disputes in a foreign jurisdiction due to the time, money, and costs involved. If your clients are consumers, i.e. individuals, then consumer laws will apply, and there are certain requirements that must be met in your customer-facing contracts. So for example, consumers have the right to a 14-day cooling off period. This basically means they have the right to cancel and receive a refund within 14 days for purchases of goods or services. So while these are key areas to focus on, every business is unique, and it's always advisable to have your contracts reviewed by a legal professional. Now that we've considered the key clauses in most contracts with your customers, I'll now let Olivia talk you through how you can incentivize and motivate your key personnel in the startup stage of your business.
Thanks, Malaikah. So yeah, when considering your how to incentivize your business's key contributors, firstly, think about whether they're an employee or a contractor of your business. So employees will work under your direct supervision, typically have set hours, a fixed salary, regardless of performance targets, and they're entitled to various employment rights and must be paid at least the minimum wage in the UK. Contractors, on the other hand, work more independently. They're often working on specific projects or an ad hoc basis, and they'll invoice you for any completed work. So for early stage businesses, obviously using contractors can offer more financial flexibility. However, as your business grows, you'll likely need to employ employees. So you'll want to consider how to incentivize your key contributors. Firstly, determining whether they're an employee or contractor, because that will determine some of the available options to you. Cash bonuses are obviously a straightforward option, but can strain limited cash reserves, especially in the early stages of a startup. So an alternative that's particularly popular with startup nowadays is offering equity in your company. So this aligns the employee's interests with the business's success. So obviously it means that, the more they contribute, the better the business does. Obviously, the better the return on the investment there. So you can offer equity in your company through shares or options. So shares provide immediate ownership rights, including voting and dividend rights. You could also issue them with a different class of shares, for example, if you didn't want them to, for example, have voting rights. And if your key concern is around sort of if they could influence major decisions. I suppose one thing to also consider with shares is they can, while they are given straight away, they can also vest and be subject to various vesting criteria. On the other hand, share options are the right to acquire shares down the track. So using various share option schemes, these can be more tax efficient, especially for early stage companies, as there are various option schemes obviously available to you. The most efficient tax efficient scheme is the EMI option scheme, which stands for the Enterprise Management Incentive Scheme. So under this scheme, the options given to employees must be ordinary shares with no preferential rights attached to these shares. And there's various criteria that must be met by both your business and the employee. So for example, the company's gross assets must not exceed £30 million, and the company must have fewer than 250 full-time employees. The employee also has to meet certain requirements, so they either have to be full-time or working for you takes up at least 75% of their day. I suppose one thing to consider there is that obviously, this is particularly incentivizing employees, given that there's less tax that they will pay if they're signed up to that scheme. So when issuing equity, consider vesting. So we touched on that briefly. If you're issuing shares straight away, you can ensure that employees earn their equity over time, typically over 4 years with a 1-year cliff, meaning that they'll start to earn their shares after the 1 year. This can be linked to performance targets or time targets, and it's useful for motivating your personnel. So you can incentivize them to work hard, ensure their interests are aligned with the business's growth, and ensure that they stay with the business over a longer period of time as well. When you're issuing equity, also consider including in the various documents leaver provisions. So these allow the board to require departing employees to sell their vested shares or options back to the company for market value. So this is particularly useful from an admin perspective, as you're not required to follow up ex-employees for signatures on corporate governance documents, and obviously frees up more of your share capital to issue to current or future business contributors instead. So equity can be a really powerful incentive to offer your employees or contractors. So it's important to discuss those options with your legal advisor to determine the best and most appropriate course of action. I'll pass back to Malaikah to talk about protecting your business's intellectual property.
Thanks, Olivia. So your intellectual property, or IP for short, makes your business unique and holds much of its value. So it's really important that you're thinking about how you can protect it. Some IP rights are registrable, like trademarks or patents, while others, such as copyright or trade secrets, cannot be registered, but are still important, and they can be protected in alternative ways. So let's start with trademarks. A trademark is what distinguishes your goods or services from those of other traders. So it can be words, phrases, logos, or even sounds. However, you can't register trademarks that are offensive, misleading, or too common. Also have a think about what brand elements are strongly associated with your business. The more unique the brand is, the more easily you'll be able to register it. But there are many considerations that you'll need to make during this process. Once you've decided to register your trademark, you should search the government's trademark register and the EU trademark register to ensure there's no existing trademarks or pending applications for similar or identical assets. This process can be complicated where there are identical or similar assets, so it's always advisable that you seek the assistance of a lawyer. You might also need to think about IP that can't be registered. So firstly, you can consider a dual company structure. In this setup, the holding company will own the IP and then license it out to the operating company. Practically, a dual company structure basically means that the shareholders will hold shares in the holding company, and the holding company will be the 100% owner of the operating company. The operating company will then carry on the business and enter into contracts with suppliers and customers or perform the services. The holding company's assets will then be ring-fenced, as the holding company holding assets, including your IP, will be protected. And there's also protection there if the operating company faces legal issues. You can then license the IP from the holding company to the operating company through an IP license deed, which gives the operating company a right to use the IP in the course of business. Next, you should also think about NDAs, so non-disclosure agreements, and these protect your IP when you're sharing sensitive information with potential business partners or manufacturers, and they typically restrict the use of shared information to a specific purpose and set out confidentiality obligations. Also really important are IP clauses in commercial contracts, so the substantial agreements that you're entering into following the NDA. And these basically outline who owns pre-existing IP, who will own any new IP created during the contract, and if there's any licenses that are going to be granted. And you should think about including restrictions on these licenses. So for example, restricting the use of the IP to a specific territory or for a specific duration. For employee-created IP, you should ensure that your contracts state that IP created during the employment belongs to the company. And where there's contractors involved, you need to ensure that the provisions in the contract explicitly assign the IP to you. That's because under UK laws, any IP that's created by the contractor does not automatically vest in you. So this is a provision you should really be careful with. When it comes to licensing or assigning IP, there are two key differences between the two. So licensing out your IP means you are allowing others to use your IP, but you're retaining the ownership. Whereas assigning your IP means that you're transferring the ownership rights of the IP completely. So those are two really important things to think about as well when you're looking at your IP and what rights you're giving to the counterparties. Once you've locked down your protection, your intellectual property protection, you should have a think about how you can grow your customer base and what considerations need to be made with this. So I'll now hand over to Olivia, who will talk through key privacy considerations in relation to this.
Thanks, Malaikah. So the Data Protection Act, which incorporates the UK GDPR, is the key piece of legislation which governs how businesses deal with personal data. So today we'll run at a very high level through some of the key things that businesses need to be aware of when dealing with personal data. So most businesses will need to collect personal data in the course of their business. So where a business makes decisions about what personal data they collect and what that personal data is used for, they will be considered a controller of that personal data under the GDPR. As a controller of personal data, the key obligations for a business include some of these things. So to identify a lawful basis for any personal data you collect, there are 6 to choose from, so you need to make sure that you've identified a lawful basis to collect that bit of personal data. So you need to then also provide transparent and detailed information to data subjects at the point of collection. So this can be done by way of a privacy policy, which we'll talk about in a moment, a little bit further. You need to respond to data subject requests. You need to register as a controller with the ICO, which is the regulator here in the UK, and pay them the annual controller fee. And other important obligations such as monitoring for data breaches and considering, your data retention requirements, so how long you can retain and use personal data for. If you're a business offering your services to other businesses, so you operate in the B2B space, you may also process personal data, which is provided to you by your clients. So they might request for you to process that personal data for a specific purpose. So for example, if your business is a software as a service business, often in those circumstances, you'll be a data processor. The key obligations of a data processor, some of those are similar to those of a controller, but some of these include implementing appropriate technical, security, and organizational measures to protect the personal data you're processing, to enter into a data processing agreement with the controller to govern the processing of the personal data, to keep the personal data confidential, so only giving access to people within your business who have a need to know that personal data, and making sure that they have their own confidentiality clauses in those employment contracts, or if they're a contractor, in their contractor agreements. To only process the personal data on the instructions of the controller. So for example, if in the DPA, it says that you can process the personal data for the purpose of providing the service, you can't then go off, for example, and take the personal data and use it for your own purposes, such as for marketing purposes. And then you need to assist the controller to comply with its obligations. So if they require your support with responding to a data subject request or responding to a data breach, it's obviously your job to help them with that as well. So in a lot of situations, it's important to understand that you might be both a controller and a processor of some types of personal data, or you might be just solely a controller, and in some very limited circumstances, solely a processor. So you need to determine in what situations you're a processor, what situations you're a controller, so that you can therefore act accordingly with the personal data. We touched briefly on privacy policies, which are required for all controllers to have in place. Now, they'll need to make available transparent information about what personal data is being collected and how it's being used. So the easiest way for a business to do this is through a privacy policy. And the easiest place to make it available is on your website, where people can easily find it. It needs to cover all the types of personal data you collect as a business, whether it's collected online, in a patient form, in any other sort of mechanism. It should all be covered in your privacy policy. And the privacy policy document should be updated yearly or sooner, where you change the way you're processing personal data. Some other documents at a very high level that you may need to put in place. So a data processing agreement, as I touched on. If you're a controller engaging a processor, or you're a processor, working with your clients who are controllers, you need to make sure that there's a data processing agreement in place. If you're a data processor, such as a software as a service provider, it's more common that you actually create a template data processing agreement and then have all of your customers agree to that during their sign-up process. For example, it could be incorporated into your client terms. If you're a data controller engaging a service provider, for example, you're engaging a new CRM provider, a new accounting software, a new contractor to help you with your development work and customer support, you should ensure that that contract includes a data processing agreement and that it's adequate for you to share personal data with that third party. Be particularly careful if for example, you're a controller, you're engaging a service provider outside the UK or the EU. Be particularly careful, because in certain jurisdictions, it's considered a restricted transfer, and you'll need to include potentially extra standard contractual clauses in that data processing addendum before you're able to transfer the personal data outside the EU or the UK. Briefly, some other documents as well to be aware of: data protection impact assessments. They're an internal document required when you're processing particularly sensitive types of personal data that is potentially likely to result in a high risk to the freedoms of individuals. You should document that is sort of basically your decision making around the impacts of that new processing. And so the ICO have useful template for that. A transfer risk assessment is a document that you'll need to fill in when you're transferring personal data to a third party, for example, a processor outside the UK or the EU or another approved jurisdiction. And you'll need to do a transfer risk assessment to make sure that the rights of individuals can be enforced in the third country. And again, the ICO provide a really useful template for that. Data retention policy is an internal document that you can have in place to specify, for example, what data you're collecting and how long you'll retain it for. And then a data breach response plan is an internal document that allows your team to understand what they should do if there's ever a data breach. Super important, because if it's a notifiable data breach, there's a 72-hour window to notify the regulator. And so really important to have a plan in place that your team are aware of and it's documented. Just lastly, super important that your employees, particularly those working in customer service or customer facing roles, are aware of what they need to do if an individual submits a data subject request or a deletion request. So again, a system should be put in place so that those people know who to go to, for example, a privacy manager, and for example, where it needs to be escalated to a lawyer. Penalties apply for not responding or meeting statutory deadlines in response to some of those requests. So you just need to be aware of, have internal awareness across your team. Lastly, I'll pass over to Malaikah to touch on some considerations for spam and marketing when growing your customer base.
Thanks, Olivia. So now that we've looked at the privacy considerations, it's a good idea to think about direct marketing and spam law considerations. Marketing goods and services is obviously an essential part of growing your customer base. And in recent years, digital marketing has become a popular way for most businesses to broaden their target audience. However, there are legal considerations that all businesses must make in doing so. So in the UK, we're primarily concerned with the UK GDPR, the Privacy and Electronic Communications Regulations, which is also known as PECA, and the Data Protection Act 2018. So these laws are enforced by the Information Commissioner's Office, which has the power to impose significant fines for non-compliance. So for example, HelloFresh was recently fined £140,000 by the ICO, and this was because they sent millions of unsolicited marketing texts and emails, including to customers who had opted out or cancelled their subscriptions. Some messages were even sent during unsociable hours. So this case really highlights the importance of complying with these regulations and avoiding those hefty fines by the ICO. Consent is another really important consideration. It's at the heart of these regulations, and so there's a few things that you should be considering. Unsolicited marketing generally requires explicit consent from the recipient, so this consent must be freely given. So this means that the individual must have a genuine choice. The consent must be informed, so the individual has to understand what they're consenting to. And then it also needs to be specific. So there needs to be separate consent for different types of communications or purposes, and unambiguous, which basically means that there's a clear affirmative action involved in opting in or opting out of the marketing. In practice, this often means using unticked opt-in boxes. So for example, there's a box and it says next to the box, yes, I'd like to receive marketing emails about your products and services. Importantly, ticking this box should not be a precondition for accessing your services or completing a purchase. It always needs to be unchecked. You should also be keeping clear records of consent, what was consented to, when and how. This is crucial for demonstrating your compliance if it's ever challenged. The soft opt-in exception. This is an exception to the consent rule, and it allows you to send marketing to existing customers without explicit consent, provided you meet 3 conditions. So 1, you obtain their contact details during a sale or negotiations for a sale. 2, you're only marketing your own similar products or services, so they can't be different to the ones that you've already marketed to them. You must give them a simple way to opt out, both when collecting their details and in every subsequent message or communication. So for example, having an unsubscribe link in emails is a popular choice for many businesses. However, this exception only applies to existing customers or those who've negotiated a sale for your products or services. It doesn't cover cold contacts or new prospects where there are other considerations to be made under the law. B2B marketing, so where you're marketing your goods or services to businesses or corporate subscribers, the rules are a bit different. You don't need consent or you don't need to rely on the soft opt-in exception. You just need to ensure that you're clearly identifying your business and you're providing contact details. Importantly, you still need to include an unsubscribe option in all your communications. This exception doesn't apply to sole traders. You should treat these as you would individual consumers, so they don't fall under the exception for B2B marketing. We'll now look at some best practices and how you can ensure that you're compliant. So to ensure you're always on the right side of the law, clearly identify your business in marketing communications, provide an easy, obvious way to unsubscribe in every message, honor opt-out requests from individuals promptly, so within 20 days at most, regularly clean and update your marketing lists, and also train your staff on these requirements. You should also be conducting regular audits of your marketing practices. And from a commercial perspective, complying with these regulations isn't just about avoiding those fines. You're also building trust and maintaining your reputation, which will also help you set yourself up for success as a startup. That concludes the main part of our webinar. You might find our UK Startup Manual useful, which you can access by scanning the QR code on the slide or through the Resources tab. We also have an upcoming webinar that may be of interest to you, where our colleagues will be discussing how you can avoid going to court when dealing with costly commercial disputes. And that's on Thursday, the 19th of September at 11 a.m. We're going to answer some of your questions shortly, but while you submit them, we'll take a minute to tell you about LegalVision's membership. By becoming a LegalVision member, your business gets unlimited access to our full team specialist lawyers for all your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost, and our team can assist you with a variety of things, including unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration, and much more. As a LegalVision member, you won't have to worry about the costs of lawyers ever again. We'll take care of all your business as usual legal work, and you can focus on running your business. To learn more about how the membership can help you, you can request a free consultation when the survey appears at the end of this webinar. And now we'll answer some of your questions. I think that the first one that we'll look at is how you can protect your ideas when working with bigger companies. And that's a really good question. And I think that's a really crucial question for startups, especially when you're looking at protecting your IP, like we mentioned earlier. So firstly, you should always be using a non-disclosure agreement before entering into detailed discussions with any company, big or small. And this will basically provide a framework for keeping your ideas confidential, especially in those early stages when you're not sure about proceeding with a business relationship. And also, as a side point, not really thinking about the legal side of things, but be strategic about what information you're sharing. You don't really need to reveal everything up front, and you should only be sharing what's necessary for the potential collaboration or partnership. And then when you're thinking about the substantial contracts that you're entering into, once you're happy to move the business relationship forward, you need to make sure you have those strong confidentiality clauses, and they extend beyond the duration of the contract as well to protect your information even after the business relationship has ended. It's also really important to define the IP ownership in any agreement, so the existing IP and any new IP that you're creating as part of the collaboration, but also think about filing trademarks before entering into discussions if your idea is innovative or central to your business, and then also keep detailed records of all information that you're sharing and when, and that's really important evidence if there's ever a dispute. And in any event, it's always advisable to have a lawyer review your agreements. And I think we've got another question here for Olivia. Do I need a group structure if I only have one product or service?
Thanks, Malaikah. Yeah, that's a good question. I suppose it will really depend on your kind of, plans for the business as well as your current sort of, arms of the business and what products you have. I suppose the decision isn't always straightforward, and it sort of will depend on a number of different factors. Even with one product, a dual company structure can be beneficial. For example, if you've got, some assets, that you want to protect by holding it in the holding company, it can be really beneficial to kind of have that sort of those assets separated out into a separate holding company for that purpose. And I guess in terms of the, the future of the business, if there are other arms of the business that you do then sort of want to create in the future, you can create new subsidiary companies to sit under the holding company. And doing that sort of from the outset means that you're avoiding a restructure in the future, and potentially some tax consequences that come with a restructure. So I guess that's probably the kind of the main considerations. Obviously, there's the additional admin of having a holding company. Even though it's largely dormant, you'll still need to do sort of company accounts and obviously engage accountants to assist you with both of your holding company and your operating company. So it's about factoring in those administrative costs you know, and weighing that up against, you know, the potential benefits of having a holding company for future asset protection and future sort of limitation of liability across business arms. So I think it's important to have a sort of a conversation with your legal and your tax advisor to discuss your plans for the business and sort of talk through whether that makes the most sense for your company. I think we've got time for one more. So what elements should be included in a privacy policy and how often should it be updated? Malaikah, do you want to answer that one?
Yep, sure. Yeah, that's a really great question, and it's something that most startups will need to consider when you're beginning to collect and process personal data of your customers, for example. So it's not just a legal requirement, but obviously it's that trust building tool as well with your customers. They're seeing that privacy policy. They know exactly what data you're collecting from them and what you're doing with that. But the key elements that you should really be including in your privacy policy are what personal data that you're collecting and how do you actually collect that, whether that's directly from the customers, indirectly, or whether you're using third-party tools. How do you use this data? So for example, are you relying on it for marketing purposes? And who do you share the data with, if anyone? And this can often be your CRM providers, any third-party tools that you're using to provide your services. And then you should also think about including how you're protecting the data and what rights those individuals have regarding their data. So they have the right to access it, delete it, for example, and then you should also include your use of cookies or similar technologies. So for example, if you're using Google Analytics or any APIs, you can include that in your privacy policy as well. And then obviously, most importantly, how users and customers can contact you about their privacy concerns. So you'd have to have your contact details on there. And then I guess another key consideration which might often get overlooked is that you need to make sure you're using clear, straightforward language and you're trying to make it as simple as possible and accessible as possible. So avoid any legal jargon that might confuse your customers. That's also another really important consideration. So I think we'll move on from the questions. So that's all the time we have for today. After the webinar ends, a survey will pop up. So we'd really appreciate it if you could complete the 30-second survey. And also, please include your contact details to receive a complimentary legal consultation to discuss how we can help you and ensure that your startup is ready for success. Thank you so much for joining us.
Yeah, and sorry, there was one question we didn't get a chance to answer, I think from Cara. So definitely get in touch with us, you know, through the contact details at the end of the survey, and we can always have a consultation to make sure that we answer your specific question.
Thank you.